Hello everyone, I'm Kumar and welcome to LiveLaw. Asking the centre to implement a new legislation to simplify and streamline bail applications, the Supreme Court on Monday underscored that investigating agencies have been lately exhibiting a mindset which leans more towards the curtailment of personal liberty, and that in a democracy, such a perception of a police state is unacceptable. A bench comprising Justices S.K. Kaul and M.M. Sundaresh also observed that jails in India are flooded with under-trial prisoners while conviction rates remain at an abysmal low. The bench further added that social circumstances of such under-trial prisoners who are illiterate and poor often compel them to inherit a culture of offence. Referring to bail laws in countries such as the United Kingdom, the bench emphasized that there is a pressing need for the centre to enact a similar legislation in India, while pointing out that the Code of Criminal Procedure as it exists today is a continuation of pre-independence legislations with some modifications. Underlining that bail is the rule and jail is an exception, the bench also asked courts to come down heavily on police officers affecting arrest without due compliance of Section 41 and Section 41A of the CRPC dealing with arrests of persons. Section 41 of the CRPC lists down offences and grounds which entail the police to arrest without a warrant, whereas Section 41 of the CRPC deals with procedure for appearance before the police officer who is required to issue a notice to the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence, and arrest is not required under Section 41. The court also noted that despite its directions in the 2014 judgment of Kumar vs. State of Bihar, no concrete steps have been taken to comply with the mandate of Section 41 of the CRPC, and accordingly ordered the state governments and the union territories to facilitate standing orders for the procedure to be followed under Section 41 and 41A of the CRPC. In its 2014 ruling, the Supreme Court had ruled that any officer, while arresting a person without a warrant on a complaint, must record the reasons for doing so in writing. On Monday, the bench underscored that Sections 41 and 41A of the CRPC are facets of personal liberty under Article 21 of the Constitution, and that any non-compliance with these provisions would entitle the accused for grant of bail. The Supreme Court also said that a separate bail application need not be insisted upon while considering the application under Section 88, 170, 204 and 209 of the CRPC. Section 88 deals with the power to take bond for appearance, while Section 170 deals with cases to be sent to magistrate when evidence is sufficient. Whereas Sections 204 and 209 of the CRPC deal with issue of process and commitment of case to court of session when offence is triable exclusively by it. Among other pertinent directions, the Supreme Court on Monday also laid down that there has to be strict compliance with its judgment in the case of Siddharth vs. State of Uttar Pradesh, wherein it was held that an investigating officer need not arrest each and every accused at the time of filing charge sheet. Opining on the need to expedite bail applications, the bench also ordered that bail applications ought to be disposed of within a period of 2 weeks, and anticipatory bail applications are expected to be disposed of within a period of 6 weeks. Thank you. Keep watching LiveLaw for more such updates.